Yes, Mayor Stripe? City Clerk Kathy Gentile?
Here.
Alderman J.R. Galogly?
Here.
So quorum present with the Electoral Board. And for the record, if I could ask the parties to state their names for the record, starting with the Objectors Council, and Objector and the Objectors Council.
Mark Lobes, 16629 South Sun Meadow, Lockport.
Matthew Campbell, attorney for Mark Lopes.
Go ahead.
Susan King, 16756 West Merck Lane in Lockport, Illinois.
And Jeff McCarthy on behalf of Ms. King.
Okay.
All right, well, I guess first order of business is to approve our minutes. So for a motion to approve those.
I make a motion to approve the minutes.
Second, were there any questions? Are we okay with them? Okay, then all in favor of?
Aye.
Okay. Motion passes. With that, just a housekeeping measure. Mr. Campbell, I don't know if you got a copy of the appearance filed by Mr. Jeff McCarthy.
I did, thank you.
Oh, you do, okay. So that's present, and I believe the first order of business is the motion to recuse that was filed, yeah.
So at the start of our last meeting, Mr. Loeb's lawyer filed a motion that I should recuse myself from the election board for an unacceptable. Sorry. Yes, so for the recusal. At the start of our last meeting, Mr. Loeb's lawyer filed a motion that I should recuse myself from the election board for an unacceptable level of bias. We took a recess to assess that motion and asked our city attorney to investigate. The rules we adopted at our first meeting, they allow the election board chair, in this case me, to make the decision on motions to either sustain or dismiss. But I think in order to avoid any appearance of impropriety, I will ask Kathy Gentile, our city clerk and member of the election board, to chair this position for this question. And so for this, I'll turn it over to you. You are now the chair.
All right, thank you, Mr. Mayor. So before I ask Sunny for some advice here, I'd like to just state that as I read through the motion, the one thing that I want to call out is that I have been a member of council for 8 years, and through the course of the 8 years, I have direct knowledge of events in which the mayor has introduced candidates, including folks that are up here, including Mark Loebs, Galogly, myself. So it was a way to meet the people and get your name out there. So, and I do have a flyer showing that Mark Loebs had been included in a prior fundraising event, and so I have copies if you're interested in a copy.
So there's copies that will be entered into record. Mr. Campbell, Mr. McCarthy, if you want an extra copy of this, I can give you copies. Sure. Okay, great. Hand them to Mr. McCarthy. So that will be entered into record. And with that, you're asking me to give you some type of legal advice
Yes,
regarding
I'd like to
that.
get your
Yes.
opinion on that
Yep.
motion.
Thank you, City Clerk Kathy Gentile. So generally, a board member is subject to disqualification and substitution where he or she, one, is a candidate of the office which relates to the objector's petition that is being filed. In this case, the candidate that is being objected to is Susan King. So obviously, Susan King cannot be on this electoral board, and in this case, this is not a recusal for the candidate Susan King. The second factor is if the board member would be a necessary witness at the objection hearing and subject to assessing his or her own credibility. So obviously, there's no indication that the Mayor Stripe would be called as a witness, and or three, holds a pecuniary financial interest in the outcome. And that's held in, and that's citing from Muldrow versus Barron, 2021 Ill App, first 210248, specifically paragraph 34. In this case, the objector who's trying to knock off a hearing board must overcome the presumption of honesty by showing in the record that the administrative proceedings were either tainted by dishonesty or contained an unacceptable risk of bias, as quoted in Muldrow's case. In this case, the motion contains a flyer for a fundraising for Mayor Strite in his reelection, and contains the flyer, I believe, in the motion contains a meet the first-time candidates. That includes Ms. Susan King, who's the current alderwoman in the first ward, and also contains meet and greet for Steve Cardamon, who is also a first-time candidate. Nothing in that flyer indicates any financial contribution in which which would rise to the level of unacceptable risk of bias. There's nothing in the motion indicate, for instance, if Ms. King won her election, that all of a sudden it would impact the financial benefit of Mayor Strite. There's nothing in the motion indicating that Susan King or Mayor Strite gave to each other's financial campaign. So nothing in that motion indicates an unacceptable level of bias. In fact, as pointed out to City Clerk Kathy Gentile, Mayor Strite has set re-election reception in which the objector in question, Mark Lopes, was one of the candidates in the Meet the Candidates. Having a Meet the Candidate is not enough to sustain that burden that the objector has to show that there's a just reason for that recusal. It is my recommendation that this motion be denied for that reason.
Could I ask a question?
The chair's actually up to the chair. Is
Sure.
Yep.
Absolutely.
Okay. So what you would give it be this, the one from 2019, were any objections raised for this election?
Were any objections raised to the election?
To any of the
Any
candidates,
petitions, anything like that?
not that we're aware.
Yeah, not that I'm aware
No,
of.
this is the first time in
Okay,
12 years that this has happened.
all right. That's all I had.
Okay, go ahead.
So in that case, Sunny, thank you for the information and the clarity that the objector did not meet the burden of proof. Therefore, in the motion for recusal of Stephen Strite, I deny that motion.
All right. Well, you're still the chair, so either you're going to hold on to it or you're going to relinquish it. It's up to you. I can't make you do anything now.
No, that was, I believe, Mayor, that was for the limited purpose of that motion to recuse.
All right.
So
Okay.
the chair position goes back to you, Mr.
Okay.
Mayor.
All right, so that said, back to the work of this board. And so the objector, Mark Lobes, candidate for Ward 1, requests that this election board rule that the nomination papers of Susan King, current alderwoman in the first ward, be insufficient in law and fact, and that the name of Susan King not appear on the ballot to be printed for the election to the office of Alderman, Ward 1, City of Lockport, to be voted on at the consolidated election on April 1st, 2025. So we will start with giving both candidates the opportunity to either give or waive opening statements. So, Mr. Lobes, you're up first for any opening statements you want to give.
And that would be directed to the council. So the opening statement by the
You can
objector's
either do
counsel is
it.
waived.
Can-
He's waived, yep.
Waived?
Do you want to make a statement? No, neither do I. I'd waive an opening statement.
Okay. And then Alderwoman King, is there any statements you want to make, or your counsel, I guess? Does our
Yes.
microphones work, or do you need to go
I-
to the podium?
No, that's good. I just wanted to state that the integrity and the validity of the signatures that I obtained personally, I was the one that met each and every one of them, that they are all valid, and I think more egregious than any, technical error is not allowing our voters in the first ward to have an opportunity to have more than one candidate on the ballot. So that is my statement.
Okay. So next we'll go into presentations. Mr. Lobes, you're up first. And so your show, fellas.
Alrighty. So.
I think we need to, do we need to swear oaths now?
No, only if they call anyone to testify.
Okay.
So, again, Matthew Campbell for Mr. Lobes as objector. We had filed our verified objectors petition, which I know you all have, so I'll just go through that just quickly. So the first element is in relation to Election Code -10-4, which is requiring that petition sheets be numbered. This is consistent with, again, Section 10-4 of the Election Code. Going through some case law that we have in this area, I cite 1, 2, 3 cases, I think, on this first proposition. The first is Walloon, which states that page numbering of section, again, which is in Section 10-4, is mandatory, not discretionary. And it also states that the court articulated that the purpose of the signature requirement is essentially twofold: requirement for identification purposes, as well as prevents tampering and thereby preserving the integrity of the election itself. Going back to 10-4, I mean, it's clear in the language. It's not a may number. It's a shall. It's a mandatory requirement that all petitions be bound and numbered, and that except for otherwise provided in that section, if they are not numbered or there's any non-compliance with Section 10-4, those petitions cannot be accepted. So that's the first one was Walloon. The second one is Jones versus Dudendorf, which state that a candidate who completely ignores the statutory elements cannot be seen to substantially comply with those elements, and then additionally, by having the papers bound and numbered, it prevents tampering, thereby preserving not only the integrity of the petitions themselves, but also to the election process as a whole. I can do this now or do it later. It's up to you, board, how you want to do it, but I do have all these cases that I have here. Do you want them now, or do you want me to wait till the end, or?
Go ahead and finish your presentation. Or do you want to, are you saying you have a bunch of cases that you want to submit in?
All the cases that I have referenced in my objection are all, I have case law for all that.
Yes, and they do have copies of those cases.
Everybody's got copies of all the cases that I have?
Yes.
Okay.
Okay. So,
Jeff, do you have?
I do.
Okay. The next one is Hagan, and Hagan essentially states non-compliance with the mandatory provisions of 10-4 requires that those petitions not be counted, and then that they not be used, and then the ones that are submitted in support of a candidate are to be denied and not used for that purpose. Additionally, we reference a violation of Section 10-3, which deals with the amount of signatures that are required and that are mandatory. We also feel that the petitions violate that. Additionally, some of the difficulty we have here is, again, in the non-compliance with the numbering provisions of the petition. The petitions that were submitted, again, are not numbered, but in going through those petitions, some of those petitions do not have a date or type of election. As we go through the petitions themselves, the first petition itself does not show the date of the election, does not state what type of election that it's for. Again, same thing, and again, I'm just saying, I'm calling this a second petition because, again, they're not numbered, but the second petition, as they were presented to us, have that same issue. It doesn't state when the election is and does not state what the election is for. The third petition that was submitted does have a date of an election of 4/1/25, does not state if it's a election for a primary, for a consolidated election, or for a general election. What I'm calling the fourth petition, again, has that same issue. None of those have the date of the election or the type of election. And actually, on this fourth petition, it states city council member ward and does not give a ward number. Fifth petition, same thing. No name of the type of election and no date for the election. And going back through those, when you look at them, the problem that you have is that somebody that sees the petition doesn't know whether or not it's for any type of election. And that raises to the level of confusion, which is a problem for the voters that are asked to sign this petition. If we go a little bit further on what I'm calling, again, petition number 6, nothing's on there. There's no date that it's been circulated, there's no date of election, and the last one, again, I'm calling it petition 7. There is no date of the election, there is no type of election listed, and it's not even signed by the circulator's petition. However, it is notarized, which again leads us to some additional issues as well. So as we go through these, probably the biggest issue that I have in these petitions is that there is no signature, or there is no numbering. As the case law is clear, the problem without numbering is that we're not able to secure these petitions. They were not bound when they were submitted, and that's my understanding, and clearly they're not numbered. The case law is pretty clear that this is a mandatory requirement of Section 10-4. This is a violation of 10-4. Therefore, all those petitions that do not have a number, which are all petitions that I've seen, require that those petitions not be considered for placement on a ballot. Overall, the signature problem strikes all of the petitions. The other issues in relation to the last 2 petitions don't have anything. Don't show what date the election will be held, don't show the type of election. All of these things, again, supported by case law and the objections everybody has, so that's good. If you review the case law, it's clear that the mandatory requirement of 10-4 has to be complied with. If it's not, those petitions cannot be considered. The confusion that you see in some of the petitions, that's referenced in the Neal case, in the Salgado case, causes confusion to the voter or the requested signatory on the petition. Those are the problems that we have. Therefore, those petitions should not be considered for placement on a ballot for Ms. King. If you look at my objection, this would be on page 5, where we talk about the problem that we have with the qualified signatures. Ms. King stated in her opening statement that all of these...
Matt, could I interrupt you for a second?
Certainly.
Is 5 the one starting with Julie Kendall?
I don't know. I can't, my 5, it doesn't have a...
What's the line 1? What's line 1? The name under line 1?
I don't know. There's a signature, but there's no printed name.
5, there's a signature, no printed name. Oh, line 4, okay. So,
I didn't count, Jeff, I'm sorry, I didn't count the statement of candidacy as a page.
okay,
So I just started with the petitions.
This, okay.
Talking about the nominating sheets.
the independent candidate petition.
There's no requirement to page the statement of candidacy.
Correct, and that's why I stated after that. And again, as you can see, as we're having this issue right now, this is a problem. This leads to confusion, this leads to not so much trust in the system. Okay, when you have these requirements that are there, and they're there for a reason. They're there to protect the integrity of an election. Ms. King made the statement before about, technical violations. Well, they are technical violations, and they're mandatory requirements pursuant to the election code, and they were not complied with. So, getting back to what I was referring to before in relation to the confusion aspect, again, the cases are pretty clear. Again, Salgado and Neal both stand for the proposition that this confusion is inappropriate, and therefore those petitions should not be accepted. Now, I had anticipated calling Ms. King as a witness. certainly if we can stipulate to the petitions that we have are the petitions that were submitted by Ms. King, I think we can probably avoid that.
We can stipulate to that.
Okay. So the petitions that I have that we've received from the board are the petitions that were submitted. And if they are the petitions that were submitted, they don't comply with the electoral code, mandatory requirements of the electoral code, and they also provide for confusion to the requested signatories, and they don't have the consistency that you need to see in petitions. Again, one of the petitions, and this is page, again, sorry, but this is page, what I'm calling page 4. At the top it says, looks like Mindy someone. But again, city council member, ward, and there's no explanation there. There are, as you well know, there are 4 wards in the city of Lockport, so it's not clear as to what position this person was running for. There's no date of circulation on here. The problem that you have is when you have a situation where you don't have the date of the election, it's not clear to a signatory if these petitions are being circulated in the appropriate fashion. As we all know, there are certain time requirements for submissions to be presented for signature, for submission. Without the reference to the date of the election, that can't be determined by somebody that looks at this petition. At this point, that's all I have. Just, oh, about the circulators? Yeah. So this is, and I don't know why this, here, can I see it? Can I see your page again? Not sure why it's this. I don't know why it's this. But on page 6 of my objection, it's labeled as paragraph C. And that essentially goes to the certificate of the circulator. So if we go through the petitions, we see one is notarized in Cook County, 2 is notarized in Will County, 3 is notarized in Will County, 4 is notarized in Will County, 5 is notarized in Will County, 6 is notarized in Will County, and 7 is notarized in Will County. However, they all appear to be certified on that same date. So, again, some of the question that we have, some of the confusion that is laid in these petitions themselves, it's unclear whether or not these were all done at the same time. If they were, don't know why you would have a Will County and a Cook County on the same petition. And again, no date of circulation. Again, some of the requirements we just don't see in these petitions. So again, I'll rest at this point with the opportunity, and I'd like to reserve the right to call perhaps additional witness or make additional argument if I desire to. That's okay.
One question, Mr. Campbell. You said that these weren't bound, but I didn't see that in the objection. Is that what?
My understanding is they weren't bound.
But it wasn't one of your 7 objections?
It's not an objection that we filed, no.
Okay.
Can I speak to that?
Sure.
That's something that we can't submit unless it's bound. They won't accept it.
Okay.
There's actually, I mean, if there's any verification, it would be the candidate's receipt that they receive, whether or not it's bound. So,
That's fine.
Okay. Thank you, Mr. Campbell.
I'm sorry,
Yeah,
Mr. Mayor, just to follow up on that. So was there one submission of these petitions, or were there 2 submissions of these petitions? Were they submitted once and then reviewed and resubmitted again?
yeah, I don't know if that's, the mayor is not the city clerk. He doesn't
No,
work in the
understood.
city
I
clerk's
was
office.
asking the city clerk.
Well, actually, the city clerk is, she has a full-time job.
She's the
so-
elected
Yeah,
clerk.
we have a deputy city clerk.
that takes the petitions.
Yep.
Okay. All right.
All right. Then, Alderwoman King, it's your response time.
First of all, as a jumping off point, we prepared 30 affidavits from 30 of the signatories to the petitions.
We could share somewhere. Go. we'll share, because, yeah.
Thanks.
From the standpoint of this proceeding, obviously, it's a question of form over substance. I understand the reading of the applicable case law suggests that 10-4 is a mandatory issue. I suggest that there's case law out there that suggests otherwise. I'd say King versus Justice Party. 284 Elep 3rd 886 from 1996 involving former appellate court justice R. Eugene Pincham when he was running for one of his Cook County offices. He submitted 100,000 signatures on 1,790-plus pages. 3 pages weren't numbered in the middle, and 16 weren't numbered at the end. The court focused on the fact that, obviously, the number of petitions or signatures that he included was over 100,000 when he only needed 25,000. And that the inherent confusion that might apply with 16 missing pages from 1,790 total probably wouldn't invalidate the totality of the filing. Noting that even if we knocked out the offensive pages, they would have more than enough signatures to meet the requirement. I'd have the board focus on the fact that this is an election that required 27 total signatures. So council suggesting that the focus on the case law is confusion. We don't really have 1,700 pages or 10,000 or 1,000 or 5,000 signatures to deal with. We're dealing with 6 pages with 54 signatures, of which I have 30 that all address every specific objection offered by Mr. Loebs, i.e. that we're all aware that they met with the circulator, who was Susan King, that she identified herself, she identified the office she was running for, seeing that this is a consolidated election and there's no primary on April 1st. They were all aware that this was for the election upcoming on April 1st for the office of First Ward Alderman in the city of Lockport. They were all registered voters in the First Ward. They attached copies of their driver's licenses to affirm that. When you look at the case law on page numbering, the case law all revolves around cases where we're not talking about 27 signatures. These are all people that I could have brought into this courtroom, and we could have questioned them in a matter of an hour to determine whether or not they were confused as to what they signed, when they signed it, and what it was for. I'd ask, especially when you're talking about such a highly technical aspect of the petitioning system, that the court really focus on a lot of the writings in Mr. Campbell's cases, wherein in the Wallen case, the Supreme Court stated, "We are mindful of the need to tread cautiously when construing statutory language which restricts the people's right to endorse and nominate the candidate of their choice." In this instance, it's a pretty severe sanction for failing to number pages, and that is to remove your opportunity to be on the ballot. But it's more of a sanction for the voters than it is for Ms. King. They don't have the ability to choose their candidate because 27 signatures did not have page numbers. I'd also suggest the court review the case out of the 3rd District, Gallagher versus Cook County Officers Electoral Board, 2024, ILAP 1st 240224, at paragraph 18. It was held that substantial compliance with the election code is acceptable when the invalidating charge concerns a technical violation, especially in the absence of fraud, and the technical defect did not impair the integrity of the electoral process. Essentially, the last case that I'd suggest you look to is Carla Sayre versus Will County Officers Electoral Board, 2012, ELAP 3rd, 120699, where in paragraph 19, it stated, "The primary purpose of all election laws is to ensure a fair and honest election." In this instance, a failure to include a page number, and truth be told, there's no mandate as to when the page number is supposed to be placed on the petition. It could be on before the signature, it could be on after the signature. It's not about the validity of the signature, it's about the objector's ability to call into question those signatures by identifying them. In this case, we have 27 signatures. Identifying them doesn't take a whole heck of a lot of time. From the standpoint of the second argument that was made in the objection regarding, and I didn't hear Mr. Campbell on this issue, so I'm not sure that it was withdrawn or not, but it suggested that in some way the fact that she offered 54 signatures was violative of 10 ILCS 510-3, where it says for the consolidated election, not less than 5% nor more than 8%, parenthetical, or 50 more than the minimum, whichever is greater. In this instance, we never got higher than 54 more than the minimum, since the minimum is 27 and we offered 54. Several petition sheets failed to identify the election or the date of the election. Again, you have 30 affidavits from signatories to the petitions who all note that they were fully aware of the fact that it was a consolidated election conducted on April 1st of 2025, and that it was an election for city council member representing the 1st ward of the city of Lockport. Objection 4, all of the petition sheets fail to identify the election type. Again, there can be no confusion when there's only one election. There's no primary. This is a consolidated election. This is win or go home. Paragraph 5, 2 of the petition sheets and fail to offer any indication of what district or area the signing voters are purportedly from. Again, 30 affidavits that say we all live in the 1st district. Here's our driver's license that proves same. 6, one of the petition sheets fails to identify for which ward the candidate seeks office. Again, the circulator has signed and had her signature notarized as it relates to the fact that she offered up these petitions to the signatories, and they were all fully aware that Susan was running for the office of alderman for the 1st ward of the city of Lockport. Again, that's reflected in their affidavits. Finally, the notary, the discrepancy in the notary, stuff on the initial page says County of Cook. That's something that the notary fills out as it relates to where the notarization took place. I don't know. That's not Ms. King's handwriting. That's the notary's handwriting, and I'm guessing it was just a mistake that he might have. He does notaries primarily in Cook County, but at the end of the day, the remaining petitions all note that they're Will County. They were all signed on the same day, November 12th, 2024. That doesn't call into question the validity of Susan King's signature, since that's what the notary was notarizing. But the biggest takeaway is, again, removing her from the ballot removes choice from the voters. And this is 27 signatures. There cannot be a lot of confusion regarding 27 signatures. And that's it.
Okay, thank you. All right, so,
They're-
Later respond to that or not?
Yeah, they do have a right to, since they're the movement, have the right to do rebuttal.
no, absolutely. I was going to say, we
Sorry.
won't jump to closing arguments. You guys can ask questions, so please.
Thank you, Mr. Chairman. Just to review some of the case law that council referred to, the King case, it is a case of multiple pages of petitions, but it's clear from the Jones case that substantial compliance is not when you completely ignore the requirement that's in the Electoral Code. So what Jones states, again, pretty clearly, is we don't believe that a candidate who completely ignores one of the statutory elements can be said to have substantially complied with it, and that's what we have here. There was no compliance with the paging requirement. And again, with all due respect to council, it's not a technicality. It's a requirement of a petition. It's clear in the statute what you are required to do. And you're right, it is 27 signatures, so it was 6 pages. You had to put numbers on 6 pages. And they didn't do it. They didn't comply with the statute. Wallen's pretty clear on what we're talking about. Again, Wallen calls it a requirement, a mandatory requirement of the election code that was not complied with. And it's not just for the objectors to know a page number, it's for the integrity of the petitions themselves. That's why it's there. Wallen says that, Jones says that, Hagan says that, all those cases say that. It's a requirement of the code, and the requirement of the code is based on the need for integrity of these petitions. It's not just a petition, it's the elections in general. And that's all I'll say in response.
Okay. So if there's anything else, then we can do closing statements? Or arguments, I should say.
Sure. Just briefly, Mr. Chairman of the board. Again, it's clear that the petitions that were tendered by Ms. King did not comply with the election code 10-4, a mandatory requirement of that section of the code. They were not complied with. Therefore, those petitions should be struck and should not be considered for placement on the ballot. Clearly, there are multiple issues with the petitions, but clearly the fact that they are in violation of 10-4 is problematic, and I think requires the board to grant the objection and move those petitions.
All right, thank you. And Alderwoman Ging, do you have any closing arguments for you or council?
From the standpoint of focus on this challenge, or focus of the challenge of confusion, the case law can decide suggests possibility of confusion, construction sites, possibility of confusion. Jones versus Building Code specifically says, the failure to number pages specifically relates to 2 factors: guaranteed identification of the signature and prevents tampering with petitions once filed. We have 6 pages with 54 signatures, with affidavits of 30 signatures, including 27. This is the epitome of form over substance.
Okay, everything? All right, friends, thank you. I guess now we'll review and we'll vote on these objections. So, Sonny, you want to outline this process of how you want to move, you think we should move forward next? We just go through one of these each at a time?
Yes, thank you, Mayor. And after hearing presentation and arguments on both sides, I do want to make sure that the Electoral Board is guided by what should be the, how you look at each of the objections. And I would suggest that we do look at the objections one at a time, and then we'll go backwards. But again, as preface, and this is actually cited on a lot of the Will County Board electoral boards, that the board's findings and their primary purpose of all election law is to ensure a fair and honest election, and that's the Carlos Serra case versus Will County Electors Board, and that's actually a 3rd District appellate case, which is binding on Will County, and not the 1st District case of Wallen, which was decided in 1995 from Cook County. It's persuasive authority, not binding. In addition, the board is guided by the Illinois Supreme Court case that was decided after the Wallen case, and that's Lucas versus Lakin. 175 ill second 166. In that case, the Supreme Court has set the precedent that there's a need to tread cautiously when construing statutory language which restricts the people's right to endorse and nominate candidate of their choice. And the Nader case, that's the most recent case, that's the 2024 case, and even though the citation is a First District appellate case, the Third District appellate court was, actually, I'm referencing the Gallagher case, I'm sorry, ahead of myself there. The Gallagher case versus the Cook County Officers Electoral Board that was decided earlier, the Third District appellate court looked at actually a statutory requirement under 10-4 in which the statute requires that the circulator's affidavit indicates that the petitions were circulated no more than 90 days preceding the last day. In the Gallagher case, the candidate put down a date range, which was, I believe, from November to March, but that was within the 90-day period. And so the objector filed saying that they did not meet the strict compliance with the 90-day, but they wrote a date that they actually encompassed the requirement, but it didn't meet the exact statutory language. In Gallagher, they said absence of fraud, the technical defect, and it was a defect of 10-4, should not impair, if that technical defect is a technical violation that does not impair the integrity of the electoral process, then substantial compliance is sufficient for the election code to be met. So, and that's the most recent case, decided after the Wallen case. So preface with that in mind, that the access to a place on the ballot is a substantial right and not to be lightly, not to be lightly denied. So with all that, that's the lens that this electoral board is looking at. And we'll start with the objections, starting backwards, because we're going to work backwards. So with that, I would look at what's the objection that's in paragraph C of the objector's petition, in which the objection is that the notarization in the circulator's affidavit sheet with Cook County is written in the subscribed and sworn of the affidavit or circulator. And the objector questions whether that actually impacts the validity of all the other petitions. But as you could tell, the 6 other sheets contain Will County. It's pretty obvious looking at the face in combination of all the petition sheets, it's a Scribner's error. In addition, there's no case law that prohibits the circulators or the petition sheet to be notarized in a different county. It happens quite often, where a candidate has a circulator that may end up, covering the 3rd district, for instance, and they could be circulating in Cook County, could be circulating DuPage County. There's nothing that will invalidate that sheet just because it states Cook County, and most likely, again, as indicated by the candidate's counsel, that is probably most likely a Scribner's error.
All right, so what you're saying here is that if it's a typo, it doesn't disenfranchise anyone. It was done after signatures, and even if it were another county, it doesn't matter. You
No, it
can
doesn't.
endorse it on the moon if you want
Yes.
to. Okay. All right, well, I guess we'll just, what we'll do here is we'll, just one of our members here make a motion to either dismiss or sustain these objections as we go along, and then we can discuss and put a vote on it, so.
And just to clarify, a motion to sustain that objection will remove and strike all the signatures from, especially if it calls integrity of all the sheets, but particularly that sheet that says Cook County, it would strike that sheet and remove all the signatures in that sheet. So that's the motion to sustain that objection. If there's a motion to dismiss the objection, that means that sheet stays, at least for now.
Okay. Any questions from,
Yeah, so we're just looking to dismiss the Cook County sheet? Is that what we're looking to do?
That's-
No,
That's the-
that's not what proposed. I thought we're proposing, this is, do we go against all sheets because the notary messed up on one, correct?
And you could do it either in that way, because it does state in the objection, but I think it's particular to that Cook County.
It says, strike all signatures from the entire petition with Cook County, not all.
all from Cook
petitions,
County.
Yeah,
So just that page is how I
Just
read
that
it.
page.
right. Okay.
But it does say this discrepancy necessarily calls into question the reliability of the notary attestation, but there was nothing indicating in the objection that would call to question the other notarization.
I'm not questioning the reliability, though. I think we all know who the
Yes.
notary is. Was a mistake made on his part? Yes, he made a mistake. I have also read that if you notarize by putting in the wrong county, basically you have voided that sheet and it should be re-signed by that notary. So technically, yeah, I would say yes to go by the rule of law. I would say that particular sheet should be a no, but I have no problem with all the other sheets because basically he is notarizing that is Susan King. And he's not notarizing the signatures, he's not notarizing all the paper above it. He's just notarizing that is Susan King. But obviously he made a mistake with Cook County, and sometimes mistakes you have to hold up to them. So that is my ruling. Well, you guys can decide what you want.
So if we look at like, so my big struggle with this whole thing has been, the Supreme Court ruling and the Third Appellate Court ruling, which, I think they made these decisions about like, look, you got to be careful about this throwing people off the ballot willy-nilly. It does affect the whole election process. It disenfranchises voters. And so is this a typo that disenfranchises voters? Does it put them out? I mean, something that even happened after they signed it. So these are the things that I'm trying to, hold on to, is like making sure that we don't violate just the integrity of the election. This is about two candidates putting their names out there, or more candidates running against each other.
Steve, I think you're looking more at the big picture.
I'm trying to decide, do we look at the
You're looking at
forest
all
despite the
7 of
trees?
them together instead of, I thought we're supposed to be looking at one
No, but-
individual after each individual.
But now I got to decide, like, is that a typo that's worth
10 signatures.
looking at, what the Supreme Court has given us guidance on about, like, is substantial compliance there? Are these signatures good? I think, is the candidate a resident of that ward? Is the candidate got their water bill paid? Is the candidate of age? And are the signatures good? That's the meat of this entire process. So this is what I'm struggling with as we look through all of these things. So I guess what we do is, and each one of these that's been my concern as well. It's looking at both what are the integrity of the petitions and what's the substance of all these petitions. So,
Can I add
we're
in
just
something?
talking, man.
Can I add in something there? My name's on this sheet. And so I signed this because, I wanted to endorse the candidate, right, on this petition to be a candidate. And I have no way of knowing who was going to notarize that, and that it was going to be notarized incorrectly, and then it would say Cook. So you would be disenfranchising those that signed by not allowing them the choice to vote.
Right, and that is really what I get concerned about, is are we going to disenfranchise, because all of this is most important, is are we going to disenfranchise the citizens of Lockport, the voters of Lockport? Are we going to tell them that a typo like this is enough to invalidate their signatures? And I guess that's the question, so.
So why don't I, again, focus on the objection that was contained in paragraph C of the objector's petition. Is there either a motion to sustain that objection or dismiss that objection?
I'll make a motion to dismiss the objection for the circular's affidavit, where all notarized on the same day by the same notary in Cook County.
Okay. Is there a second to that objection?
I mean, I can second it,
Yes.
all right. And then we'll,
But see, you're confusing what, what it is. Are we talking one page, or are we talking all the pages?
the
Well-
page with Cook County on it.
That's what it is.
That's, if
Okay.
that's what it is. It's actually like specifically what's contained in paragraph C of the objector's petition. You're either sustaining that objection for the reason outline, for the reasons outlined in C, or you're dismissing it. There's a motion pending, motion to dismiss that objection as contained in paragraph C, and there's a second by Mayor Strite. And if there's no further debate, I would call the roll. So I'm going to go through Alderman Glogly.
No.
That's Mayor Strite
Yes, I vote to dismiss.
and Kathy Gentile.
Yes.
Okay, the motion passes. That motion outlined in C is dismissed.
All right, so what's our next one on here?
It is, working backward, we're going to, objection that the petition sheet did not identify for which ward the candidate seeks office. That's in paragraph B6, in which it says one of the petition sheets, and again, without page number, it is difficult to characterize which one, but obviously everybody knows. One of the petition sheets fails to identify for which ward the candidate seeks office. There'll be more than one election up on April 1, so I believe that's according to,
Well, during Mr. Campbell's
1, 2,
presentation, he said it was page 4.
4, yes, page 4, because that's the only page that,
So it says first ward on the top, this is the voters of the first ward, and they can't vote for alderman in any other ward. So is the fact that one isn't next to ward in the office that they're seeking, is that enough to violate? I mean, is there,
yeah, so I believe that case that the Objectors Council cited, Sagado versus Marquis, which is 356 Ill App 3D 1072. That case, the candidate didn't even put the office. He just wrote full term in the candidate's box. So in that office box, the candidate, Mr. Sagaldo, Solanco, or is it Sagaldo, he just put full term instead of, alderman, mayor. So the case holding is you can't, there was, again, nobody knew what office was, that person was running for. If you look at the petition sheet on its face, you would think the qualified voters in the first ward would be voting for a candidate in the first ward. You can't just, that one being missing and the first word being on the top, when you look at the whole entire page, I would, for
and then
me.
your submission of these affidavits is that the testimony was that, and what they've all signed here, is that they're very well aware of what this election was. They're, okay.
Yeah, as I read it, that top section indicates the ward, and the folks that signed it are saying they're in that ward, so
Okay.
I can make a motion to dismiss the petition sheet that does not identify for which ward the candidate seeks office. Page 4.
Yeah, I can second that. We could do a roll call.
Yes. Alderman Glogly?
Yeah, I vote to dismiss as well.
Okay. Mayor Stripe?
I vote to dismiss.
Kathy Gentile?
I vote to dismiss, yes.
And that motion passes 3-0.
All right, next we have, related to 2 sheets of the petitions that contain the ward numbers or the city of Lockport in the beginning of the paragraphs. Objection number 3.
Yes, that's the,
Objection that the petition of the that 2 of the petition sheets contain no ward numbers or the city of Lockport in the beginning paragraph of the voter. So that's our last 2 pages here that I don't have anything in the header, right?
Yes.
These are the ones we're referring to?
Yeah, 6 and 7.
So, do you want my opinion regarding these, or? Yes, so, one of the factor for 10-4 is that the electors who are signing the petition have to be qualified electors, and they're certifying that they are in that ward for that, and they're qualified elector, they're, registered voters, in other words. So that's part of the top of it, we, the undersigned qualified voters in Ward 1 of, city of Lockport, that would indicate that the voters are in that Ward 1. I understand that there may be affidavits indicating that they are in Ward 1, but without the top qualifying statement that they're in First Ward, it could be somebody who's outside of the ward who may just sign it. So with that, it doesn't meet what the statutory, and this is a little bit more than failure to page or not having or Scribner's error in Cook County. This is something which the elector is stating that they're qualified primary electors, and they reside in that district in which the candidate is running.
Okay, so your thoughts are the last 2 pages of the signatures that have both 4 and 2 signatures total, that you're thinking,
There are insufficient, substantially insufficient.
okay. All right, so we'll look for a motion on that one.
I make a motion to sustain the 2 petitions contain no district or area on the signing, and that we remove those signatures.
Okay, I can second that motion.
Okay. Chair Galogly.
Sustained.
Okay. Mayor Strite
Yeah, I'll sustain that.
and Kathy Gentile.
Yes.
So that's, motion passes to sustain that objection. The last 2 pages of the candidate's petition will be stricken and removed.
All right, so now we're on number 4, and that is objection that all of the petition sheets failed to identify the election type and the date of the election as April 1st, 2025.
Yes. So under Section 10-4 of the Election Code, there's nothing in that code that requires the date of the election or the type of the election. What's required is that the signatures were signed more than 90 days preceding the last day of the filing of the petition. And in the petition bottom, that's affirms the circulator that the electors who are signing are qualified electors, and that they are, to the best of their knowledge, well, they're not circulating anything more than 90 days preceding the last day of the filing petition. So that date is in there to make sure someone's, not circulating it earlier, for maybe election, in 2026. It's in there, but, it's pretty obvious that we know that that there's no primary, and one of the reasons why you put a primary or, the regular consolidated election is if there was a primary. This is, I think Lockport for years have run independent candidates. There's not a primary. So having the actual election date and the type is not a requirement under 10-4. So I think this objection should be dismissed.
All right, looking for a motion.
I'll make a motion to dismiss.
Okay, I can second that. Want to do a roll call, please?
J.R. Glogly,
Yes, dismiss.
Mayor Stripe,
Dismiss.
and Kathy Gentile.
Dismiss.
All right, next we have an objection that several of the petition sheets do not identify the election type or the date of the election that will confuse voters and call into question the circulator's affidavit. This one I was having a little trouble with understanding the difference between that and the one before it, but.
Yes, so number 5 goes to paragraph, at least paragraph B3. And B3 states that Oh, 3, are we going 3? No, we moved on to 5, yep. So 3, that goes to paragraph B3, and that states several petition sheets fail to identify election or the date of the election of which the candidate seeks to win office. Specifically, all of the sheets do not include this information. So they're moving to strike all those petitions.
All right.
Not just the one that may have 4-125, instead of April 1,
I got you.
2005.
All right, so
yeah.
everything without a date, which,
Yeah.
again, I think the affidavits in my mind do have weight. If you're going around getting everybody, they're like I wasn't confused. I get that this isn't, a Chicago ward election where you have 1,000 signatures. It's like, you're going around and you looked at everybody in the eye and told them what you were doing. I don't think there was confusion. Okay. Looking for,
Yes, I did circulate all of them. Most of them are my neighbors or friends, people that I know. They knew, we made a joke that it was for the election on April Fool's Day, how ironic is that? So that was part of it. They knew it was the consolidated election, it was a people election, and they knew that it was for one.
Yeah, I would just ask the electoral board to disregard that because it's
Thank you.
that's
it's
the only
been
time.
close, yeah, it's been
Okay.
close.
I was actually, when I said
Yeah.
it, I was
Yeah,
just
so, yeah.
saying what was testified about earlier, so.
So that will not be considered.
Okay.
So was there a motion?
I don't think we made a motion yet, so.
I'll make a motion to dismiss the claim on several petitions do not identify the election type or date of the election.
Okay. So
Okay.
Kathy, is there a second?
I can second that.
Okay. Mayor, and roll call for J.R. Galogly.
Dismiss.
Yes, okay. And Mayor Stride
Dismiss.
and Kathy Gentile.
Dismiss.
Passes. Is there one?
All right, so now we move on to objection number 6, objection that the nominating petitions have a total of 56 signatures, more than 8%. That one seems like it was just not accurate at all, like the numbers were not over that.
Yeah, I think it was just looking at the 8%, but obviously the statute allows or 50 more than the minimum, which would be 77, not
77, okay.
56. Yeah.
So I make a motion to dismiss.
Second.
Okay. Do a vote, please.
J.R. second. Okay. J.R. Galogly,
Dismiss.
Mayor Stride,
Dismiss.
and Kathy Gentile.
Dismiss.
Okay.
So finally, the
Now comes number 7, yes,
yeah,
whether
7.
pagination.
Yes, and as indicated by, as I stated earlier, the Wallen case, even though it may state that pagination is a statutory requirement, and therefore the candidate was knocked off, that case was decided in 1995, I believe. A couple years after that, that's when the Supreme Court decided in the case of, I'm going to go through, of, gosh, we are right over here. In the case afterwards, gosh, I can't pull it over here, reading to me, okay, here it is. That, whenever the board is looking at the objections and also the nominating petitions, that it must tread cautiously. There's factors for that. We need to be mindful that, oh, here's the page, okay. That need to tread cautiously when construing the statutory language, which restricts the people's right to endorse and nominate the candidates of their choice. And in the most recent case out of the first district, in which the third district appellate court case decided, it's the Gallagher versus Cook County Officers Electoral Board, in which, in absence of fraud, the technical defects that do not impair the integrity of the electoral process should not invalidate or knock someone, again, off the ballot. the invalidating charge if it concerns a technical violation and does not impact the integrity of the electoral process, that the substantial compliance with the election code is acceptable. So with that in mind, I know that Wallen case has that failure to page is, is a defect and not in compliance with 10-4. But again, the purpose of paging a petition is to prevent fraud. There's no allegation that all of a sudden in the middle of the night, somebody snuck an extra piece of petition sheet into a candidate's nominating papers. It's kept in a safe place. All the nominating petitions are. There's no allegation of fraud. The second purpose of paging is to identify signatures that you want to knock off. If there were thousands of pages, in which Cook County candidates, you do have to submit thousands of pages. If you fail to page thousands of pages, it's going to be hard to figure out in page number 788, there's an issue with line 4 of a signature that person who signed doesn't actually reside in the area, or they're not qualified or registered voters. So the purpose of pagination, the purpose of protecting, and why you have, paging, it doesn't apply in this situation. Number one, the Wallen case is a first district appellate case. It's a compelling. It's not binding to this electoral board or to the circuit court, appellate court. And since then, the cases have been more of protecting the integrity of the election process and not disenfranchising the voters. So while the Wallen case may directly address paging, it is a persuasive authority. Supreme Court has set a different sea change regarding being careful about not, knocking off anyone and not getting the voter a choice. And that was reaffirmed in the 2024 case. So with that, all that in mind, is failure to page worth, not giving the voters a choice?
Okay. Thoughts or comments?
My comment is technology has changed since the 90s, and where filings were originally paper form, things are digitized now. And once this motion was made for the objections, we got digitized copies of Susan's packet. And so each page is identified in the digital packet. So we have page numbering in a sense. So I think the more current citing that Sunny shared with us is where I will land, and I'd make a motion to dismiss that the petition sheets are not numbered, that issue.
Do you have a thought there, Jeremy?
I have some thoughts.
Please.
Is 10-4, what would you call it, an election law, election rule? What do you call this?
Election code. It's
Is election code.
form of petition for nomination.
Okay, so later in 10-4, it says, and this is just something different, whoever forges any name of a signer upon any petition shall be deemed guilty of a forgery, and on conviction thereof shall be punished accordingly. So this same 10-4 is like a law, saying if you do something wrong, we hold you accountable. And you're shaking your head, so you agree. So also, you keep on going with the people you keep on calling out is Lucas versus Lakin. We are mindful of the need to tread cautiously when construing statutory language which restricts the people's right to endorse and nominate the candidate of their choice. That is directly followed by, we hold that the Electoral Code does not require that the address in the circulator's affidavit on nominating petitions filed pursuant to Section 710 be identical to the address where the circulator is registered to vote. So you're reeling off something that has nothing to do with page numbering. You're reeling off something that has something to do with the integrity of the circulator. So this is a rule. I mean, some people make mistakes. And at one time, and I can't even say who the name was, When we heard this topic was coming up, somebody said that was a fatal mistake. And I don't know if anybody wants to go back on that, saying that this was a fatal mistake, and sometimes mistakes are fatal. And I'm going to say this is a rule, this is a law, and then we just saw it in another local town where they said, you know what, our hands are tied. We can't have, except, we like that person, or exceptions to the law. And this is one where we have to stand firm, because in 4 years or 2 years from now, when the next person comes, goes, well, now we're going to change our mind. This one is a rule that we need to follow as a board, and I'm going to say, no, I do not vote to dismiss, I vote to sustain.
Okay. My thought on it is, the Supreme Court was, saw how, even when we started this job 12 years ago, it was always a circus. Everybody was trying to get everybody thrown off the ballot for every little technical error that they could find. And it was chaos. And I think where the Supreme Court has come down on this over the years is like, look, it's the integrity of the signatures, substantial compliance. Are the signatures good? Is the, person qualified to be in office? This is what's most important for all of these things. If pagination made it a little more difficult for us to figure out what pages it was, so be it. I think we got through it pretty easy. Because what's gonna happen is if we throw it out for pagination, which just made the objection process a little more cumbersome, you're gonna disenfranchise all of these voters.
We got those after the fact because it was done wrong, right?
Say that
No,
again,
guys, why do we have these? Why are these here in front of us?
Because you had a person who's running for office that's never done this before, and, it wasn't
No, I mean,
perfect.
well, I think, aren't you admitting guilt by coming up with 30
No.
affidavits?
From my perspective, what it's showing is integrity of the candidate. And the whole purpose of this code is to show the integrity of the candidate, right? And that's where that, if their forgery shows that they're not they have
Wait,
no
nobody's
integrity.
questioning the integrity of the candidate. I
But
mean, not.
that's where
but-
forgery comes in, right? Because you're trying
Right.
to say, are the signatures valid, right? Was it
Right.
done with what's the intent?
The intent,
of
right.
the petitions?
Okay, and you say, okay, I'll keep talking. Are people confused when they sign this? People keep on going, was somebody's confused? So somebody from Orland Park goes, no, I'm not confused, I know what I'm signing. Or somebody who doesn't even live in that ward says, I know what I'm doing, I'm not confused, I know what I'm signing. So don't say there's not confusion or everything here is perfectly done. And I'm sorry, sometimes if a mistake is made, it causes, Steve, why are our papers perfect? Because yes, there was a time where we had to do it perfectly, because you know what? Everybody questions it, and they still question it. Don't think it was back in the day, back and now. It's being done constantly. Sure. This is what happens in our field. It's very difficult to run for elections, and there's a lot of homework, and you need to do your job.
Yeah,
And
yeah, that's
so
fine.
you could say what you, yeah.
I do too. I just feel like if there's not even another candidate on this, you'd have a single candidate running now because somebody got.
You do
thrown
not
off.
you can have a write-in candidate. We've done it in this town before. Are we denying somebody a write-in candidacy?
No, nobody's being denied a write-in candidacy.
Okay.
But you know that, it's a person who I think did their best to get it done. And I think like disenfranchising all the voters and even the people that came back out again and did an affidavit, I think it's really looking out for then the voters of the first ward and telling them they're not gonna have a choice on the ballot is what it is. And I think that goes back to the Supreme Court decision that says, substantial compliance, and in this case, it was, the signatures are good. And, people signed affidavit. Nobody filed an objection about the signatures. And so, for me, I go back and use the Supreme Court holding of, substantial compliance.
Yeah, and what I find is interesting when you go back to 10.4 and up at the top of call it the top, it's talking about what the petitions contain and what the candidate's responsible for, and then at the bottom, such sheets before being presented to the electoral board or filed for the electoral district shall be neatly fastened together by placing the sheets in a file and fastening them together at one end, and then the sheets shall then be numbered consecutively. So it sounds like it's just an administrative task. It does not sound like it's systemic to the candidacy. It's academic. I already made the motion, so.
Okay, so,
There was a motion made to dismiss the objection. That was made by Kathy Gentile.
Yes.
Is there a second to that motion?
back in second.
Okay. Yeah, that's right, second. Jarek Logley
No, I object or sustain.
and Mayor Stripe,
I dismiss.
Kathy Gentile.
I dismiss.
All right.
So with all the objections reviewed and the two last sheets being removed, that there's sufficient signatures in which the board will be ordering the city clerk to print the name of Susan King upon the ballot for the April 1, 2025 consolidated election for the office of Alderman, Ward 1, City of Lockport, Wood County, Illinois. So the parties are informed that if they feel aggrieved by the decision of the board, they may seek judicial review of this decision by filing within 5 days of this decision a petition with the clerk of the circuit court along with a proof of service to all parties. I will make these changes. I should be back in about 10, 15 minutes for everyone to sign and get a copy.
All right, so don't adjourn until that's done, is what you're saying?
Yes, because we do have to, it was announced, but to officially sign off before the electoral board is adjourned, because we have to then reconvene another meeting. So I'll be right back.
Okay.
Okay, now that the parties received their copies of the order, the electoral board can adjourn their meeting.
All right, so looking for a motion to adjourn.
Make a motion to adjourn. Second.
All in favor? Okay, thank you, everyone.